Okay, you're live.
Okay, awesome. Well, thank you for allowing us to come into your all's abode today. I know we've been here, it's probably been a little bit, and I think I was last year talking about seller impersonation. And Leslie, she had come to me and she'd said, Mel, we're gonna go back and do another lunch and learn with True North. And I was like, awesome, tell me when. And she did, and then I was like, okay, what are we talking about? And she said estates. And I don't know if I visibly, kind of was like, ugh. But that did happen, at least mentally. And I was like, okay, Leslie, estates, really? And she said, yeah, but I want to do it differently. And I was like, okay, what's your idea? And she said, you know, oftentimes we talk about what we're going through when we're handling an estate or whatnot. I want to take a different side of it this time. I want to look at it from the agent's perspective. I want to think about, all right, so if they're going out to a listing appointment and they know that the homeowner, it's an estate now, what does that look like for them? You mentioned you do a lot of listing appointments, and I thought, okay, we're talking to you then. So this is, you're going to hear a lot of things that maybe sound familiar, and you are going to hear the title part of it, but what we want to do is give you an idea when you get the questions from your clients, how you can respond to it, what that looks like to them and for you. Because essentially whenever we do anything, we try to approach it as where we are coming from, rather. We want to look at it through your eyes, through our client's eyes, through the buyer's eyes, through the seller's eyes. That way we know that we are better prepared to handle any situation. So ultimately you all aren't surprised when you come to sit at the table. So with that, Ms. Leslie here is going to take it over.
So you guys feel free to ask questions. This can be a discussion type thing. I don't want you all to feel like you all can't ask questions. This is Rachel Slover. She's our other title agent in our office. This is Katina Thompson. She's our marketing director. And then you all know Mel or Melissa. She's our VP of operations. So, and I'm Leslie. I'm the Johnson City office manager. All right. So when you go to that listing appointment, or if you have a buyer and they're like, well, it's an estate, what do I do? This is, the first thing that you're going to want to do is probably ask a few questions. My first question would be, when did that person pass away? It has to be 60 days after that person has passed away that's selling the property before we can close. That's to allow any unrecorded deeds to be recorded, or anything to come through for the estate as far as claims and things like that. Of course, some of you probably know that if there's a will, that means that they died testate, and if they died with no will, that means they're intestate. And so those...
You use those words in your appointment, you're going to sound really smart.
Yeah.
Are you testate or intestate?
Yeah.
So, maybe not. So.
You might get some disrespected folks if you say it incorrectly.
There you go. There's that. Well, there's that.
Intestated?
A little gassy, but not.
Oh goodness. And then of course, you've got to try to figure out, well, who needs to sign a contract? Who's going to be signing the deed? Property that's owned solely by an intestate person, of course without a will, means that passes immediately upon their death to their heirs. Property that's owned solely by someone that died with a will passes immediately to the beneficiaries named in their will. So that will helps us to determine who needs to sign the deed. There has to be very specific language within the deed that brings the real property into the estate.
Within the will.
Within, what did I say?
You said deed.
Within the will, that brings the property into the estate. If not, then, just that personal rep or that executor cannot sign a loan. They would have to have the heirs and everybody sign with them.
And it's really hinky, the language that she's referring to, because sometimes you think that the will reads like, okay, this is supposed to be taking care of the personal rep, because it says the personal rep can sign on my behalf, or, can do all those sorts of things. They have those powers. But our underwriters, they say no, it needs to be specifically, because property actually passes outside of an estate. So you actually have to have language that says this property is to be made part of the estate and be administered as such. So that's where there can be, your clients aren't going to know that. And that's okay, we don't expect them to know that. But if you all know that that could be a possibility, then you can prepare them. Hey, we're gonna let the title company review it first and then see what's actually going to be needed. And we want to be that person for you. So whatever questions they have or you have, we want you to shoot them over to us. Also, can you all see this okay? It's not really adding anything, but we do have Miss Tina and Miss Rachel here. They are great at charades and interpretive dance. So anything that you all need illustrated, we'll totally do that.
I'll vote on that.
Okay? Yeah.
You heard that, you heard that.
Well, that was part of the program already.
Right? Okay, and then we got Nathan in there too. He'll put his own spin on it.
To will or not to will, that is the question. So of course, I just touched on this a little bit, but we use the will to determine who the beneficiaries are of the estate, and make sure that they are available to sign as devisees of the will. Thank you, Nathan.
Thank you, guys.
Of course, some concerns that we have, are they over the age of 18? Are they living? If they're not living, then that opens up more things. And then, do they have any additional concerns that may hinder their ability to convey clear title, such as a lien?
So with what Leslie's saying here, one of the concerns of the beneficiary being under the age of 18, do you all know why that would be a concern?
You're not an adult.
Because, exactly, and so we would need to have a guardian ad litem appointed for them in order to represent their interest in it. And then the same thing as well, if a beneficiary, like let's just say that they have dementia or something, you're gonna have to look at it from, a custodian will probably have to be appointed in order to represent their interest in the estate as well. So there's a lot of nuances there. Again, you all don't need to know it, as we do. So.
Just to give you an example, so we currently have a file. Son thought that he owned the property, son signed the contract, we get the search back. He does not own the property. His mother, that is deceased, still owns the property. She has 11 children. 3 of them have died. So we are now working through all of that. But Tammy in our office is great about, she's like our own private investigator.
At that point, you can get the rest of the 8. What about the other? What do you need for the other 3 to be eliminated?
So we would have to go to their next of kin or their heirs.
So
if they have a will, then we have to look at what their will says. If there's no
That's
will,
And it seems like it always comes in waves. Like we'll get like 3 estates or we'll get like mobile homes. It's random.
that seems to work in threes.
Yeah. I know. So when there's no will, of course, the clients don't want to probate, and who conveys the property? If there is no will, our underwriters do require an affidavit of heirship that kind of takes the place of a will. It kind of has the same information on it, and that has to be signed by a disinterested third party, a friend, a pastor, or somebody that knew the family and can say
That's familiar with,
that they didn't have a living spouse, they didn't have any kids, and things like that. And we would have that recorded before we could close. So, can we close yet?
I imagine you guys sometimes, okay, so this came from, I imagine you all sometimes with your clients being like a parent driving on a road trip with your kids in the car, and they're like, are we there yet? Are we there yet? For you all, it's probably, can we close yet? Can we close yet? Can we close yet? And you all being, it's coming, it's coming. Okay, so just to let you know, that's, does it happen like that? Sometimes maybe?
Depends on the complications and
Okay,
or if they're not doing this, or if they wanna point fingers at somebody else.
Oh,
Depends
goodness.
on the situation.
oh goodness, okay.
But usually if you build enough rapport, it's like, it won't over communicate. No news is still news.
Okay, there you go, there you go.
And we do try to make it a point, like if we get a search back and, we know that it's gonna take a little bit more time than, what maybe is on the purchase contract, we do make sure to let you guys know that as soon as possible, because we don't like surprises, and we know that you all don't like surprises either, so. So, of course, when there's an estate, we have to worry about TennCare claims. They do not have an expiration date, whether there's a will or not a will. we do have to get something from TennCare stating that there either is a payoff or that they never had TennCare before we can close.
Where does, like, cause I've heard certain things, like, with TennCare, like if somebody goes into, like, a hospice care or something, does TennCare take over their property at that point? Is that?
And will you kind of rephrase that for the people who are?
I'm saying I'm not loud enough. I can be a lot louder, Karen.
It's quite hard.
Yeah, so he asked if they're on hospice, does TennCare take over their property? They can in some instances. I guess it just depends on how long they had to use those services and how much, and then the property value. I don't really know the specifics of how they determine.
And what I've seen is they typically will just put the claim against the person, and then they wait until you go to sell whatever assets you still have. Yeah.
Yeah.
So it's not really so much that they can't just go take title to your home.
Okay.
They
And
actually,
what does that process look like if you have TennCare, like what happens at that point?
that's when we go to get, when we go to reach out to TennCare and we say, can you let us know where they stand? They'll send us a payoff.
Okay.
And then we know, okay, we gotta collect for this at closing, or, they'll send a statement that
That makes
says
a lot more sense.
that it's a waiver. And then further on that as well, what can happen is if the claim is so large, the estate might be insolvent, meaning there's not enough funds to cover
For
everything. And so when that happens, there's a little bit more finessing that you have to do. Obviously, we wanna have an estate attorney involved at that point, because they'll have to run it through the court system, and then the court system needs to actually determine how the funds are gonna be handled and what's gonna be paid off and what can be released and whatnot. So, yeah, there's a little, and we aren't gonna know that necessarily at the very beginning either. You
No.
guys definitely aren't. So that comes from a little bit more, digging around and whatnot, so.
And we've also seen them where they release the claim if there's a TennCare claim. So very, very rarely, in my experience, there's been a few TennCare claims.
They
But,
like their money.
yeah. So.
Mm-hmm.
So of course, unpaid creditors have the right to file claims against the estate, whether the will is probated or not. If the will is probated and a notice to creditors is published, funds can be dispersed to the owners after 4 months from the first publication date. If there's no probate, then funds can be dispersed 12 months after the date of death.
As far as closing, what does that look like?
That doesn't really affect closing for us, because we can hold the funds in escrow until either one of those deadlines is up.
Okay.
Perfect. Yeah,
So-
I think I had one group that was like, oh, we can't close. We're gonna have to wait 4 months or something. I was like, oh, what? And then, I talked to the probate attorney, and he was like, oh no, we can close right now. Like, I can close it. We just hold funds.
Yeah, there's really, our underwriters require that we do not close until the 60 days.
Okay.
And also a TennCare. So as long as we've got those things back, typically, unless there's just something that's a little weird with that one, and frankly, I've never seen two estates be the same. So there is probably gonna be something a little weird come up. But those are our non-negotiables.
Okay.
We have to have the TennCare for sure, and we need to wait that 60 days for sure, so. And the reason also, I'm gonna mention this too, because we were talking about all those heirs. Another thing too is with creditors' claims, out of those 11 heirs, when we go check title on them, because we have to, if one of them has a judgment lien against them from like a Discover card that they used, guess what?
Really?
As soon as the property passes to them, which it would when the person dies, then whatever liabilities they have against them that are of record are going to attach to the property as well. So yes, that becomes an issue also.
So we also wanted to talk just a little bit about trusts. A lot of people think that because if you put a property in a trust, that it would protect you from going through the probate process, and it does in a way. But from the title perspective, the property can still be encumbered by claims. So creditor claims and TennCare claims can still apply, and they must be resolved. So we would just need to look at a copy of the trust documents, the trust certification, and then we can go from there as, you know, who needs to sign and things like that.
Fun fact on trusts, you have to start the process. I had a client that his wife passed and he was the sole person in the trust, and just he never did anything with it. And so he just kept being like, yeah, I'm selling the house. And then as we were going, they're like, well, the trust hasn't been done up. Like, it had to go through this process. The trust outlined of once she died, this would happen on this day, this would happen on this day. Well, he just held it until it was like a week out from closing. And then we were like, oh.
Didn't realize you had
So
those
then he had to like go to a judge, get this order on it that allowed him to do exactly what we were doing. Even though it said that, it needed to be ran out. So make sure if somebody says, like, oh yeah, I'm gonna trust or something, that it's already in the process, or you will not close.
Yeah, sure.
So life estates, who can sign when there's a life estate involved? So of course, life estates are not to be confused with estates. They are a legal arrangement where the person holds the right to use and enjoy the property during their lifetime. And when they pass away, the ownership automatically transfers to a designated person or entity. You know, if they die and they do have a life estate, no probate is needed, but we would still have to get a 10-care payoff or a release may be required.
And the reasons for that again are because TennCare's gotten, you know, they're clever. And they're like, well, you can't just transfer your ownership and keep a life estate and think that we're not going to try to recoup. So
You'll see TennCare on like all types of properties, or is this mainly in some sort of on average price point or
Yeah.
like that? Or?
TennCare, it doesn't, unless you're, was it 54 or 45? I can't
I
remember.
think 45.
45? Unless you're under the age of 45, we don't have to worry about TennCare in those cases. But over that age, we have to go reach out to TennCare to see if any of those benefits were used.
Okay.
So it doesn't matter. You could be selling the home for $150,000. You could be selling it for $1.5 million. It wouldn't matter. We would still have to reach out and find out.
Do you see a lot of it on the higher end stuff?
The
TennCare.
That they had 10-care.
Yeah.
no, and that, I guess that makes sense, wouldn't it? So
Yeah, the average person who's gonna be getting 10.
Yeah,
It'd be
exactly.
like, you know, yeah. So
Because it's based on, it's usually against
Income.
So no, not really. But we still would have to get the waiver.
okay. That
So
sounds good.
yeah.
Okay. That was my question.
Yeah,
Shut your mouth.
Oh, me too.
I think was more question, but I was
No.
also thinking of that.
You know, and if it's a cash deal, you know, if it's a cash deal and it's been probated, you know, as long as everything's in place and the only thing that we have to get is the 10-care, that doesn't usually takes 1 to 3 days,
Oh,
most of the time. The only time we've seen them take a little longer is if there is a payoff. But back to the life estate. So here's some examples. If the property is vested in John and Jane Smith with a life estate retained by Margaret Smith, Margaret dies. Of course, her interest no longer exists, and John and Jane would be our only sellers and would have to sign the deed. Example 2 would be John and Jane Smith and Margaret Smith. Margaret Smith is alive and kicking and wants to sell. When they go to sell, all 3 would have to sign because she's still living. So she would have to convey her interest in the life estate as well.
What happens if she wants to sell on John and Jane? No.
That's going to be a problem.
Yep.
That's going to be a problem.
They're
So
not,
a
they're
lot
not
of
in it
times,
on Judge Judy or
when
something.
we see this happen, it'll be like Margaret has the property and she just wants to go ahead and convey it over to her kids, to her daughter and son-in-law and whatnot.
Yeah, I've seen that.
Exactly. And so, you know, if she's still alive and kicking and like say she just wants to move into a condo now, a lot of times the kids, they're going to be like, well, this isn't our house, it's her house, we don't want to have anything to do with it. Well, ultimately, they have an interest, her life estate has an interest, so all of it has to be conveyed. Now, it could be that we can arrange to do a quitclaim deed between the kids back to mom, to where she's the sole owner, and therefore all the proceeds go to her. So we just need to know that up front, and then we could totally work with the parties in order to facilitate what they're needing.
No worries, I can sign on their behalf.
You heard that, Jones?
So just a quick thing about power of attorney. So once a person dies, of course, their power of attorney document is no longer valid and cannot be used or relied on. Any document would need to be signed by either the devisees of the will or the heirs at law of the estate.
On your contract, for your all's purposes, you'd want to know who the personal rep is, and they could sign off on your contract. But for our deed, we would want to, again, depending on how the will reads, we would want to have any heir, any devotee of the will to sign off on this, so, on our deed, so.
Why is the title company asking me these questions? So we want to protect your clients, the seller, ensuring that they have the legal right to sell and won't face any future claims. We want to protect the buyers, making sure that they of course receive a clear title without any hidden hairs, unpaid debts or legal challenges, and of course identifying potential title issues before they become closing day surprises. So if you guys have any questions at any time, even before, let's say you're getting ready to list something and you have a question and they have a will and you want us to look over it or something, we'd be more than happy to do that. You can email me or JC Orders or, whatever, but we'll be happy to help you guys along the way if you have any questions.
Did I put that in bold enough? I sure hope so. I hope everybody can read that.
Triple bold.
So, we do have a list of employees they've been there for a long time and they're very knowledgeable. Like I said, Tammy's great at identifying these from the get-go and getting things rolling on what is needed for estates. And we also care. We know that there is a deceased person involved and it may be hard on the family. So, we try to take that into consideration and be empathetic and things like that, so.
I was going to say that because I think that's actually one of the strengths that you have going on in your office is the fact that your clients are not just file numbers to us. We legitimately look at it as, with an estate in particular, obviously there could be an issue. Somebody's feeling sad. It could have been their childhood home that they're having to sell now. And as a result, there's a sensitivity that we want to have with your clients, for sure.
And we've even had them come to the table and cry, and I'm sure you guys have been in some of those too, so.
But with regards to being well-versed and whatnot, I just want to brag for just a second. We've got six licensed title agents in our company, 6. There's some companies that don't even have one. And you've got actually 3 here with you right now. I think that that's something to be really proud of because what that means is that we continue with our education and we really want to stay on top of things. We have a great relationship with our underwriters. We're underwritten by both Fidelity, Chicago Title with Fidelity and also Westshore. We love working with them. We're a top producer with Fidelity, which for the state of Tennessee is saying one because there are some big ones out there. So we pride ourselves on what we try to do to make sure we're handling your files and your people to the best of our ability, so.
And just to add to that, communication is big for me. So we try to have top-notch communication at all times.
That's key.
Yeah, it is. And depending on how you all want to communicate with us, it might look different. Like you might just want a text from us, or you might want an email, or going through our encrypted server or whatnot. However or you want a phone call. There's people that want us to pick up the phone. That's okay. We're good with that.
I prefer mailed letters.
Do you like the snail mail?
Snail mail.
Does your files close on time?
No.
Files? What are you talking about?
Just out of curiosity.
Production. Okay.
I saw you standing up the other night.
Do you guys have any questions?
So whenever you go on a listing appointment, what's kind of like a good mental checklist once they say this is an estate?
Is there a will?
Okay.
Do you have a copy of it?
Okay.
I'd like to shoot it over to my title company so they can look at it real quick.
When did they die?
Yeah, when did they die? How many brothers brothers and sisters do you have? So, but I think starting with that,
Has
how long,
it been in probate?
what's that?
Has it been in probate?
Has it been appropriate? Yeah.
And has it been released?
Yeah.
Those are
But
good
being in
questions.
probate's not a game changer for us. We can
No,
work
it's
it
not
out
a
right.
game changer, but it's real important to know what the process you're
That's true.
in, as a realtor.
And
Very important.
If it is in probate, who's your estate attorney? Can I go ahead and get their contact info? So,
We can still get paid if it's in probate too.
Yep.
Correct.
absolutely.
They can hold money and still pay us too.
That's exactly right.
Yeah.
Yeah,
They feel comfortable. that-
the escrow funds
Yeah.
is for the seller's proceeds.
Yeah.
Everything else still gets dispersed as
There's
normal.
a good chance you're gonna get paid, so don't.
Yeah, the first thing that I do when I hear them say that, I go, okay, great. Was there a will? Was this going through probate? And then they're like, yeah, it's through that. I'm like, great. Are you the executor of the will? Yes. Okay, great. How many heirs? And then I do that, and I go, okay, good. Well, let me see if I can have a copy, bada. And then I just go to the title company. Really, I talk straight to their attorney first. Like, are they good to sell? And
Absolutely.
then from there, then I'll, usually on my intro email, be like, hey, this is what we're doing, just heads up.
Yep.
Here's contact information, here's their attorney, here's this.
Yep.
So that way, I can at least introduce it,
That's perfect.
so I don't go in there
So
blind.
you're asking the right
Yeah.
questions already, and it sounds like you're even going a step beyond that as well, so that's awesome. That comes with the experience also, so.
You get in trouble a few times, you're like,
Oh, Lord, don't I know it.
And if we know that ahead, and like as soon as the search comes back, if we already have all that information, it makes things so much quicker for us to get the ball rolling and get what we need if there's, if we still need things, so.
Yeah, if we know it's an estate, especially at the very beginning, we can go ahead and have our abstractor start checking probate files as well.
Yeah.
So she does that as part of her search. That's mine.
You got a little squirrel in
I
there?
do. Are you familiar with Phineas and Ferb?
Yeah.
That's
Yeah,
that's carrying the platypus.
You got Perry in there.
I do.
So like a good thing, whenever you're going into that listing appointment, it sounds like whenever they say estate or probate or my mom died or dad died, the biggest thing to do, it's
Give them a big hug.
get information.
Yeah.
Yeah, be empathetic on
Yeah.
that. But like, get the information, but then also, don't trust them saying like some of the things in here, like, yeah, I'm good, I can sign it. Oh, I
Yes.
don't have that estate thing, but yeah, I'll get it to you. Let's just get it on the market. Because it's just like what y'all just said, you had one where it's the brother, and we had another title company here that was saying that they had one that was getting all the way up to closing, and they said they were the heir, and they gave them documents and stuff. Ah, get me!
Yes, I'm so sorry about that.
But they went all the way right up to closing, and then it found out there was like 5 other brothers and sisters.
Oh, no.
Oh, no.
But they had just been the one to move in with mom and felt that they were entitled to the proceeds. And so they had actually I think they might have had like a forged document, like they're the sole heir. And then how they called it, I think they looked at an obituary.
That sounds safe.
And the obituary was like, my loving children. And, they're
Yes.
like, oh. And then they grabbed them and then ran that way. And we're like, what the? And that person just got super upset. It was like, well, I'm the one that moved in with mom. So I think keep that in mind. People, I've seen it a whole lot, and I'm sure y'all have.
It is my son. My apologies.
Yeah.
He's the only one that can get through when I have it on Do Not
Yeah.
Disturb. So my apologies.
No worries.
If you need to take
And,
that, take it. Absolutely.
He's got to where I started thinking for the podcast. But it sounds like we need to make sure we have that information documented and that we're actually getting it because, as we've said, when people pass, yes, you can get emotional and sentimental. People also get weird when they can get some serious money and they've done nothing for it.
That's
Absolutely.
the truth.
You know what I mean? So it's like, especially, we're in some spot, it's a certain individual that doesn't really have a whole lot of money, and it's like, you can get 60,000. Now all of a sudden, we're like, well, how can I get more? So just document, go down the path, because what you don't want to do is be negligent, take somebody's word for it,
100%.
and then you're at closing, and people are mad at you because you have to take 2 extra minutes to get documentation.
We've had those situations happen where people are seeing dollar signs and so things kind of turn. They take a turn for the worse. But most of my experience has been they just don't know. Their brothers and sisters said, oh no, we want you to have it, it's yours. We don't want anything from it. And so they're coming to it from that perspective,
That's
not
good.
realizing all of this other stuff is happening.
Yeah.
We don't expect them to know our process. We love being here to talk to you about our process, but we don't expect you all to know it either.
Mm-hmm.
so that's why we definitely are open. We want you to call us whenever you have those questions, whenever you're in a tough spot. Please feel free to call us, email us, whatever you need to do, because we don't want you to be in that tough spot with your client. So,
Has your property been through probate, Matt?
Yeah. The one closing today. We're closing today. Yeah.
and so the beneficiaries are all settled and you've got everything.
She's the sole beneficiary, so that was.
Okay, well, that's helpful,
well.
that's for sure.
Poor thing, stressed out of her mind.
Okay,
She's been handling the payments, all that by herself, and all sorts of.
So I might have missed this, but, okay, so if they're the executor of the will and it's an estate, do they have to present a death certificate as well?
It's
As
usually,
part of the process, and, I mean, he mentioned obituary, but,
so we actually, a lot of times if it's probated, the death certificate will be in the recorded documents with the probate docs, but if not, we always get a copy of that. And we also go ahead and pull the obituary, we'll just Google it. Because like he just said, you know, we do that at the beginning so that, because we don't want there to be any surprises. So, death certificate, we, you know, pull their obituary so that we can see exactly who the family says that their heirs are.
okay.
Most lawyers and title companies and judges, they're very good at this. It happens every day, all day long. So
Yep.
I doubt you're gonna do anything new. And if you do, they'll probably get excited because that'll be something they hadn't seen already.
It can be a little stressful at times, you know, just because you want to get your client to the closing table and you want this to end up good for everybody. You know, and we work under the gun a lot, but I think that's just part of all of our jobs, you know.
I'll probably say this and then it'll just blow up. I've never had one that was that difficult. It's just time consuming, but
It
you
is.
just go through they tell you exactly what to do. If you do exactly what they say and whatever the court tells you to do, and you can never fool a judge. He sees 1 million of these a day. It's like a robot when you go in there. He just says, okay, do this, get out of here.
Yeah.
You know, he'll call you out. There'll be 10 people in there and he'll tell all 10 of them the exact same thing. Go do this, you know. And the only thing they ever ask me to do sometimes is give comps on what a property is worth,
oh, sure.
you know, and then he approves it, and that's pretty easy, and then you're gonna get paid, you know, you get your commission, and then at closing. So it's really not a complicated thing, you just keep everybody calm, like she said, don't let them erupt. Okay? Because once somebody one of the sisters realizes that the money that they would have gotten, or they not gave it to the sister, they don't wanna sign.
Yeah,
Yeah.
that's also,
And that's the problem you're gonna remember, everybody has to sign. Irregardless, even if a judge says, okay, this person gets it, if it's a sister, the lawyer's still gonna ask that person to come sign. Now, a judge can say, I'll sign off for her, but that's another process you gotta go through.
yeah.
And that takes a long time to get over, but for the most part, it's pretty smooth.
Yeah, judges, they have to be so specific if they're going to assess somebody out of property.
Yeah.
And I mean, that language has to be, we have to go over with a fine tooth comb to make sure it's going to satisfy. The last thing that we want for our buyer or for our seller, because we don't want anybody trying to come back and sue them either, and for us and for you, just everybody.
You give them title
Is-
insurance,
That's precisely right.
Yeah.
That's precisely right. So we just have to be very careful. It's the risk, you know, it's the risk. But you were talking about having one that wasn't, you know, you not had one that's been that complicated. I had one years ago. This is back in Greene County. And I had 4 siblings that knew of each other. Well, there was one that Dad kind of had, you know, and had another one. And that one lived in.
His name wasn't Bill Cup, was it?
That one, he lived in New Jersey with his mom, and come to find out, the sibling that had come to me about it was very forthright about it and just said, "This, I just know about him, so we have to take care of this." Found out that one had died in New Jersey, and he had left a will and left it to his mom and his stepdad. Both of them subsequently died, and so it just kind of took a turn. And New Jersey is different than Tennessee. New Jersey attorneys are a lot different than Tennessee is. Yeah. And so that one,
It might have to be probated in New Jersey too,
it
right?
was so crazy because it went down like so many different tiers. I had to draw like a family tree
Oh, no.
just so I could follow the people involved. And then at one point, the attorney that I was working with said, we don't do it that way here. And I said, send me an email with regards to that, please. And he did. I ran it by my underwriter. My underwriter said, he should know what he's doing in New Jersey. We're fine with this.
Yeah.
And so I was finally able to get it closed. But that one probably took me probably half a year, truth be told. Because nobody was wanting to work with anybody. They were ultimately maybe going to be walking away with $150. And for them, it wasn't worth it, you
No.
know? So it just is what it is. But
Yeah,
it did get resolved.
that's a rare one though.
Yeah,
Pretty rare.
if I could find some wood. We don't want that one again. But anyway, do you all have any other questions? Okay. Well, thank you so much.
Thank you guys.
We have the food set up for you.
Very helpful.
Yeah, thank you.
You're real nice, not like you said, man.
Mallory,